Huge and great breaking news out of Minnesota, where a federal judge has just struck down a ban on 18 to 20-year-olds being allowed to carry guns in public for self-defense under the Second Amendment. We're going to talk about this when we get back. A great opinion. Check it out and let's discuss. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the four boxes of American liberty. Okay folks, huge great news here on Friday. The United States District Court for the District of Minnesota has declared that the state's ban on 18 to 20-year-olds being allowed to get a permit to carry guns in public for self-defense is unconstitutional under the Second Amendment. A very strong opinion here by Judge Menedez in support of a case brought by the Minnesota Gun Owners Caucus, the Second Amendment Foundation, the Firearms Policy Coalition. Congratulations to all three of those groups. I want to read the order to you first, and then we're going to break it down so you understand what a good job this judge did. This is what the order says right up front. The state of Minnesota requires a person to obtain a permit to lawfully carry a handgun in public, but does not issue permits to anyone under the age of 21. The plaintiffs, who are 18 to 20-year-old individuals in firearms advocacy organizations with members in that age range, argue that the minimum age requirement in Minnesota's permit to carry law violates the Second Amendment's right to keep and bear arms. The judge then goes on to say that the Supreme Court's recent decision in NYSPRA versus Bruen compels the conclusion that Minnesota's permitting age restriction is unconstitutional, and the plaintiffs are entitled to judgment as a matter of law. Huge win. Congratulations to those organizations, to the plaintiffs in this case. Excellent news. I'll put a link to the decision down below, and let me break it down. I should say that Judge Menedez, I'm not surprised, even though she was appointed to the federal bench by Joe Biden, took her job seriously and honestly and did exactly what an Article 3, quote-unquote, inferior judge under the U.S. Constitution is supposed to do when confronted with Supreme Court precedent on point, which is you follow the Supreme Court precedent whether you like the outcome or not. And I'm guessing that Judge Menedez maybe personally is more of a pro-gun control person. I'm just guessing. The fact is she did her job as a judge and upheld her oath properly with respect to supporting the Constitution, the Second Amendment, and the Supreme Court precedent of Bruen and Heller. So overall, I thought Judge Menedez did a great job in this case. It was a very strong work. She did a good job analyzing the case. To begin with, she started, as you're supposed to start, with the text of the Second Amendment, and then she pointed out that you interpret the text of the Second Amendment, which is the right of the people to keep and bear arms, based on 18th century understandings of the words. Specifically, each of those words have been defined by the United States Supreme Court previously. She talked about the right to keep, to bear, what those all meant, and specifically she talked about how the people in Supreme Court precedent today includes basically all Americans, and by definition, at least on the plain text analysis, that would certainly include 18 to 20-year-olds because they're obviously part of all Americans. So that was a good start for Judge Menedez. She then points on that after step two, after gun control law implicates the plain text of the Second Amendment, which obviously a restriction on the right to carry guns in public for self-defense clearly does, because it infringes on the right to keep and bear arms. She then says that she has to do a historical analysis, but she can't just, and this is very important information and very good news for us. There was competing sort of theories of argumentation about what Judge Menedez should do here. There was what I would say the plaintiff's pro-Second Amendment side was arguing properly, in my view, that the holding of Bruen specifically says that it is up to a district court judge to find the historical tradition of firearms regulation going back to our founding. And this is very important because the word firearms regulation has a particular meaning. A regulation is a law that is enforceable, that if you don't follow, you can get into trouble. Now, that was the theory articulated by the Second Amendment Foundation and by the Firearms Policy Coalition and by the excellent Minnesota group out there, arguing that you have to actually find historical analogs at the time of our founding that justifies a restriction that 18 to 20-year-olds had no right to keep and bear arms at the time of the founding, that they're somehow, by virtue of historical analogs and the longstanding tradition of firearms regulation, excluded from the word the people once you do the historical analysis. The Judge Menedez then looked at the case specifically and looked at the historical analogs and says there's no way, no how, there's nothing close to this in her opinion. And she points out one of the good evidence is that, she cites to the Militia Act of 1792, which we've talked about, that says that really, of course, the Second Amendment is adopted in 1791. The Militia Act of 1792 is adopted a year later, and by the Congress, and says that 18 to 20-year-olds have an obligation to serve in the militia. And this is very telling because if you have an obligation to serve in the militia, you are supposed to bring your own personal firearms that are commonly owned at the time to militia musters. That would be your own gun, your pistols, your ammunition, your black powder, whatever it is. You had to bring your privately owned weaponry that you had on the farm, that you had in your home, whatever it is, and bring it to militia musters, right? So obviously, it's a no-brainer that you can't have 18 to 20-year-olds obligated to bring firearms to militia musters in 1792 if they don't have the right and ability to go out and buy them and acquire them on their own initiative because there's no way for them to work. So that's very telling that she said, yeah, that's exactly right. Now, I should talk about this other theory. Now, I've just described really the pro-Second Amendment view, that you have to find actual historical laws at the time of our founding. There's another view articulated by the anti-gunners and by the state defendants in many of these cases, and essentially the theory goes like this, that you cannot look just to historical analogs and find the laws. You need to talk to historians, and you need to basically allow historians to opine in court that as they stand, this is my phrasing of it, that as they stand on the riverbanks of history, watching history flow by, they get to identify narratives and context and airy-fairy concepts that basically allow them to rewrite the meanings of the actual text of the historical analog regulations at the time of our founding. And I'm happy to report that Judge Menedez looked carefully and basically says, I understand the argument about context, but the reality is I am instructed by the Supreme Court to look for the historical tradition of firearms regulations in interpreting whether or not there's a long-standing tradition of regulating firearms in a particular way. The example I always give is you cannot use a firearm at the time of the founding to commit murder. You cannot use a firearm throughout American history to commit murder, i.e. to misuse a firearm. That is an example of a long-standing, a historical tradition of a firearms regulation or law that's long-standing and understood to be exempt from the text of the Second Amendment, that you cannot use a gun to commit murder. That is understood from the beginning of our country all the way through today. That is the sort of thing that the anti-gunners have an obligation to identify to justify modern-day gun control laws, and the reality is they can't do it because at the time of our founding in 1791, there were very few gun-related laws even on the books, and most of that related to misuse of firearms and not just the peaceable carrying or the peaceable holding for firearms for purposes of lawful things such as self-defense for hunting, target practice, or whatnot. Okay, so she basically rejected the historian's arguments that, context is there, but that's not the law. I have to follow Bruen, and basically does a great job on that. Just to put this into context, she points out that the Minnesota defendants' arguments is that, quote, context is key to understanding historical analogs to Minnesota's permitting scheme from the founding era. So you can see what they're trying to talk about when they use the word context here. The anti-gunners, as I see it, as well as the government defendants trying to uphold these anti-gun control type laws. They're trying to say we get to look at context, which as I see it is really kind of a mealy-mouthed wiggle room opportunity for them to rewrite American history and get away from objective information and objective facts based on historical laws. They want to talk about other things besides the actual laws as I see it, and I think it's about the laws. That's how I read Bruen. And actually, Judge Menedez agrees with Mark Smith here because this is what she writes when she rejects the state's arguments. This is what Judge Menedez writes to reject the notion of context. She says, quote, but persuasive as one may find this criticism, Bruen instructs lower courts that, quote, when a challenged regulation addresses a general societal problem that has persisted since the 18th century, the lack of a distinctly similar historical regulation historical regulation addressing the problem is relevant evidence that the challenged regulation is inconsistent with the Second Amendment, period, close quote. So again, here she says, it's my job as a lower court judge to look at historical regulations, which are actual laws. And again, not general concepts of history and that sort of thing, which we've talked about before, because the holding of Bruen specifically says you have to identify a historical tradition of firearms regulation, which means binding, enforceable laws at the time of our founding. I should also mention she did talk about the debate between 1791 and 1868, which is what I've written about extensively. I'm guessing my articles were cited to her. I don't know that for a fact, but I'm pretty much sure that everyone cites to my work in this context. And she basically agreed with my viewpoint. She specifically said that the Supreme Court has repeatedly says that because you can't have one interpretation of the Second Amendment or any aspect of the Bill of Rights that applies to the federal government, and then a different interpretation that applies to the states. I mean, you interpret the Bill of Rights at 1791 because that only applied to the federal government, and then you have a different interpretation of the adoption of the Bill of Rights as applied to the states in 1868 when the 14th Amendment was adopted. She says the Supreme Court says you can't do that. It has to have one understanding, and because the Supreme Court has made it crystal clear that the way to understand a law when it's adopted is to ask yourself, what did the people who adopted the law think they were adopting when they adopted it? And obviously, when the Second Amendment was adopted in 1791, the question is, what did the Americans think in 1791 when they were adopting the Second Amendment? That's the key. It's totally irrelevant what happens 80 or 90 years later, except possibly as a confirmatory analytic, which is not an issue here. And bottom line is she essentially agreed 1791 is the key historical period, which I think is very powerful. She also made a reference to I'll make one last point here. She also has a footnote in her opinion where she says a college-based restriction from the year of our Lord 1838 is too late to be considered the founding era, which I could not agree more with. I think the founding era really does end around 1826 on the year that Jefferson and John Adams both pass away, although you could extend it a couple more years if you want to extend it, I think to 1836, the year that James Madison passes. But again, she said that 1838 is too late, and I concur with Judge Menedez. So the bottom line here is big win for the Second Amendment. 18 to 20-year-olds are now, at least in parts of Minnesota, I'm not going to get into the details of how this law will be enforced and what this order means, but the bottom line is you have a federal district court judge in Minnesota has concluded that the Minnesota ban on 18 to 20-year-olds from being able to carry guns for self-defense in public is unconstitutional under the Second Amendment. I think that's a major victory for the Second Amendment, and we'll see if the state appeals or what happens next, and I'll keep you informed. And I'll put a link to the opinion down below. Okay, folks, hope you learned a little bit something here today. Wanted to give you some great news about the Second Amendment today on this Friday. And again, we'll see you soon here at the Four Boxes Diner.
Orders up. Table 2A.